How family violence affects partner visas. Most partner visa applicants make the same mistake when they fall victim to family violence at the hands of their sponsoring partner. They think leaving a relationship means losing their visa. That fear keeps people trapped in dangerous situations and stops them from using the legal protections that could keep them onshore and safe. So in this video, I'm going to break down exactly how the family violence provisions work, the evidence you'll need, and how you can keep your visa application moving forward without staying in an abusive relationship. Hello everyone, I'm Walt Collis, your trusted migration lawyer. Before we get started, a brief trigger warning. We will be talking about examples of abuse and mention fictional scenarios for illustrative purposes. Certain topics of discussion in this video might cause feelings of anxiety or distress, but it is important to talk about this openly and honestly. So let's get started. What family violence really means under Australian immigration law. So let's say you've moved to Australia on a partner visa, leaving behind your family, your friends, and the safety net that you once had. At first, things are going well between you and your partner, but then they start checking your phone. They question where you go. They control how much money you can spend. They ban you from seeing your friends. They never lay a hand on you, but you feel trapped. Here's the important part. Under Australian immigration law, that still counts as family violence. The law doesn't just focus on physical injuries or hospital visits. It includes anything that causes you to reasonably fear for your safety or well-being. That can be physical harm, yes, but also emotional abuse, sexual pressure, financial control, and psychological manipulation. If your partner threatens to call immigration every time you disagree with them, that is coercive control. If you are blocked from speaking to your family overseas or forced to hand over your income, that is abuse. The law even recognizes cultural harms, such as being pressured to provide money or gifts to a spouse's family in ways that are exploitative or tied to dowry demands. The harm doesn't have to be visible. The stress of being isolated, degraded, constantly on edge can be just as damaging as a physical injury. That is why immigration officers are trained to assess both visible and invisible forms of harm when looking at partner visa cases involving family violence. So if this sounds like your situation, the next question is, can you still get your visa if you leave the relationship? That's where the family violence provisions change everything. How do family violence provisions protect you? Here's where most people get it wrong. They think if the relationship ends before their permanent visa is granted, the application is over. That fear keeps many in unsafe homes far longer than they should be. The truth is, the family violence provisions exist to stop abusers from holding visas over someone's head. If family violence happens while the relationship is still ongoing, you can leave and potentially still continue your permanent partner visa application. This applies whether you are in Australia or overseas and covers subclasses 309 and 820 and the respective permanent residency subclasses of 100 and 801, as well as prospective marriage visas that lead to partner visas. So imagine you're on a subclass H20 temporary partner visa waiting for your permanent stage, but the abuse escalates. You move out, scared, but determined. As long as you can show that the violence happened while you were still together, the Department of Home Affairs can assess your case under the family violence provisions. If your evidence is accepted, your visa will not be refused just because the relationship ended. That's the point of this law, to protect you, not to punish you. But knowing the law is one thing. Proving your case to immigration officers is another story entirely, and that's where many people stumble. Proving your case with the right evidence. This is where many applicants feel overwhelmed. It's not enough to simply tell your story. You have to prove it. The stronger your evidence, the better your chances. You must frame your narrative and have evidence to back this up for Home Affairs to believe your claim and act accordingly. A strong starting point would be for you to write a statutory declaration explaining what happened in your own words. A police report might back up an incident you described. Medical records can show when and why you sought treatment. If you saw a psychologist, their notes can help show the emotional impact of the abuse. Digital evidence can be powerful too. A text where your partner apologizes for last night, an email containing threats, photographs of damage or injury can help connect the dots. Let's say police are called to your home one night. Hospital records show treatment for stress the next morning, and you have messages from your partner begging you not to leave. That paints a clear and consistent picture. One tip, keep your documentation safe. Save copies in secure places away from your partner's access. Use cloud storage or ask a trusted friend to hold them for you. These details can make or break your case. But once your evidence is ready, the next step is to not make the mistake that can ruin your progress. Common mistakes people make when using the family violence provisions. One of the biggest mistakes is waiting too long to act. Some people hope things will get better and delay collecting evidence. And while that's very understandable behavior, we acknowledge that human relationships are extremely complex. This delay can actually be detrimental to your dream of living in Australia. By the time the abused partner decides to leave, crucial records like text messages, emails, or even police reports are gone or harder to access. Imagine discovering months later that your phone has been wiped, your email password changed, and the evidence you needed has now vanished. Another common error is relying on weak or incomplete evidence. A short supporting statement from a friend that just says, "Yeah, I think they were abused," it's not enough. The department looks for strong, detailed, and consistent records, ideally from official sources like police officers, doctors, or mental health specialists. Without them, your case can look like it's built on hearsay instead of facts. Some applicants also misunderstand the timing. The violence must have happened while the relationship was still considered ongoing. If you leave a non-abusive relationship and months later an unrelated dispute happens, it will not qualify under the family violence provisions. Also, many people try to handle everything alone without legal advice. This can lead to missed deadlines, incomplete forms, or sending evidence in the wrong format. All of these mistakes are avoidable with the right guidance from the start. Here at Australian Migration Lawyers, we can step in early and help you understand your legal rights. Understanding the legal process and your rights. Once you tell the Department of Home Affairs that you have experienced family violence, your application is looked at through the family violence provision lens. This process is separate from any police or court proceedings, though they can run side by side. You have the right to go to the police. You can apply for a protection order. You can have a lawyer represent you in both family and migration matters. And you don't have to keep living with your sponsor or have contact with them while your case is being assessed. If the evidence confirms abuse, your sponsor could face criminal charges and even lose their ability to sponsor in the future. For you, the priority is safety. That might mean moving to a family violence refuge or established safe haven, getting financial assistance, or accessing counseling, all of which are available in Australia for people in this extremely vulnerable position. The department knows abusers sometimes threaten to cancel your visa as a way of control. This law was built to remove that power. Your rights stand whether the abuse was physical, emotional, financial, as long as you can show it happened during the relationship. But even with these protections, the reality is that leaving can feel impossible. And that's because of the challenges victims face beyond the law. The real challenges victims face. Even with these protections, leaving is not always simple. Fear of losing your visa is one of the biggest reasons people don't speak up. Misinformation, often spread by the abuser, makes victims believe they'll be deported the moment they walk out. Money is not a barrier. If your sponsor controls the finances, you may not have rent money, a phone, or even access to your passport. Add language barriers, no nearby friends or family, cultural pressure against ending your marriage, and it becomes clear why people stay silent. Take someone who moved from overseas, speaks limited English, and whose only income comes from casual work arranged through their partner's contacts. Leaving means losing that income, their home, possibly their whole community. Without the right support, it can feel impossible to break free from abuse. That is why speaking to a migration lawyer early can change everything. We can explain your options, help you gather evidence, and connect you with supporting services. We can also handle communications with the department so you don't have to. This takes the pressure off and reduces the risk of being re-traumatized during the entire process. If you're wondering where that help starts, there are services ready to answer your call right now. How Australian migration lawyers can help you. If you are facing family violence and you're worried about how it affects your partner visa, speaking to an experienced migration lawyer can be the turning point. At Australian Migration Lawyers, we have helped countless clients continue their partner visa applications after leaving abusive relationships. We can guide you through gathering the right evidence, prepare your case for the Department of Home Affairs to assess, and represent you every step of the way. We know these cases are not just legal matters. They are deeply personal and often traumatic. That is why we offer confidential consultations, handle communication with immigration on your behalf, and connect you with trusted support services for housing, safety, and counseling. You don't have to navigate this alone. Contact Australian migration lawyers today to book a confidential consultation and take that first step towards protecting both your safety and your future in Australia.